And I've received the PSI. Have all the parties received a copy of the PSI, or for the benefit of Ms. Cummins, the pre-sentence investigation report?
The state has, Your Honor.
Yes, Your Honor.
I want to commend you folks on getting this matter resolved through mediation. Mediation is a good process. It's not always successful, but when it is, it bestows the benefit upon the defendant of being able to control her destiny, for lack of a better term, as opposed to what may happen if you proceed to trial. Nothing forces you to do it, but sometimes defendants like to determine the outcome of things, or at least know going in the door what's going to happen. So good job to all of you on that. So with that being said, Mr. Mosher, you had something you wanted to address with the court?
Yes, Your Honor. Prior to proceeding with sentencing, Your Honor, I'm requesting that the defendant undergo a UA. Based on my observations, the observations of law enforcement, and the observations of court personnel, I have reason to believe that the defendant is impaired or under the influence. She is currently subject to bond conditions to where she is not to consume illegal controlled substances or alcohol, and is subject to random UA, breath, or blood tests. And based on that and the seriousness of these proceedings, I believe that my request for UA is reasonable.
Ms. Premier, what's your position on that?
Your Honor, I would object. My client is not under the influence of any illegal substances. She does take prescription medication. So Judge, we would object at this time.
Well, I think the number one question I've got is, does your client actually take prescription medications? And if so, what are the side effects or contraindications?
Judge, she takes, it's like a non-narcotic, but it's for muscle relaxer.
And does she take all of those simultaneously, or are they staggered throughout the day?
Judge, she takes in the morning, and then the other one she takes at nighttime.
Mr. Mosher, what's the basis? What phenomena or symptoms have you observed that makes you think that a UA may be appropriate at this time?
Your Honor, the behaviors I'm seeing, I would associate with what I've observed previously, what law enforcement described to me as tweaking. And I can try to bring the officer in if you want to hear more from him, if that's the case, Your Honor.
I think the best way to handle that is we bring him in and we actually swear him in, and I'll allow you to ask your questions, and then I'll allow Ms. Premier to do that.
Yes, Your Honor. Your Honor, he got called for a EMS run on a life flight, but he believes there's other personnel to cover, so he said it'd take him about 5 minutes to get here.
Okay, if we can stand in recess at this point. I will caution you, Ms. Premier and Ms. Cummins, that the underlying conviction in this case is in fact for unlawful possession of a controlled substance, which is methamphetamine. And if in fact if the court orders that you were to submit to a UA, I'm going to be very, very concerned if in fact you test positive. And maybe think about that for a few minutes, and maybe.
I mean, I can tell you now that my client will likely test positive. I don't think that she's currently under the influence at this time. I've met with Ms. Cummins on numerous occasions, and I don't see a change in her behavior. That's my observation. Clearly, she does have a drug problem. That's why the plan was to get her on probation, get her into a drug and alcohol evaluation, and then hopefully get her into treatment. But personally, I don't think that she's under the influence today.
Well, okay, she does have a bond condition then that requires her not to utilize drugs. Additionally, she's a convicted felon at this point. There's an admonition, I'm sure, from Judge Velez that she wasn't to utilize any substances between now and then, or not to engage in any unlawful activities. And the concern becomes, okay, based on my fairly knowledgeable experience with this, there's a fairly short lifespan on the metabolism rate of the methamphetamine compound. So that would indicate most likely recent or heavy usage. So, Mr. Mosher, if we assume for a second that she's going to test positive and she does not challenge it any further, what would the state's position be?
Your Honor, I to some extent, I would leave that to the court. I'm just concerned if Ms. Cummins is impaired to, and this isn't the first time I've encountered this type of situation, I've taken the same approach. Given the seriousness of the situation, I'm concerned with going forward with sentencing if she is in fact test positive.
Okay. If that's the case, then I most likely will probably agree with the state, because the last thing they'll really want is an individual who ostensibly is under the influence, particularly if her counsel has a good faith basis to believe that she will test positive, and we will continue the sentencing, and I will probably want her taken into custody until she presents with a clean urine sample, and then secondly, she'll be tested before her next sentencing hearing. So, why don't I go off the record? Ms. Premier, you go and talk to your client for a minute while we wait for the officer, and then you let me know what you want to do after having time to consult with your client.
Judge, I have consulted with her. Well, I'll talk to her and then I'll be back in a few minutes. That's fine.
All right, we'll stand in recess. Kansas, we've had proffer. Well, let me get back on the record. Sorry. We are back on the record in State of Kansas versus Jennifer Sinead Cummins. The case number is 20 CR 17. Ms. Premier, I've provided you an opportunity to confer with your client in confidence in regards to the state's request for a pre-sentencing UA. They've at least proffered a good faith basis, and you've at least proffered some disturbing facts. I left the ball in your court. The officer is now present and can provide the court with his testimony. Have you, after discussing with your client, how do you desire to proceed at this point?
Well, Judge, I mean, she will test positive. I don't know that the officer's testimony is needed today. I don't know if he's ever even met her previously, but Judge, I could make arrangements for her to get a drug and alcohol evaluation between now and her next sentencing. It is my understanding from my client that she has been, since her release from jail, she has had long periods of sobriety and then would relapse. She has had two recent deaths. A stepson of hers passed away in June, and then recently a friend of hers